Board of Immigration Appeals. The Board of Immigration Appeals, BI, part of the U.S. Department of Justice, is the highest administrative body for interpreting and applying immigration laws. It is located at the Executive Office for Immigration Review, Eoir, headquarters in Falls Church, Virginia. The BIA hears appeals from decisions made by immigration judges and by district directors of the U.S. Department of Homeland Security, DHS. Moreover, the BIA is responsible for the recognition of organizations and accreditation of representatives requesting permission to practice before DHS, the immigration courts, and the BI. The BIA reviews decisions by immigration judges and has appellate jurisdiction over family-based immigrant petitions under INA 204, as well as orders of removal and applications for relief from removal, criminal immigration matters, and motions for reopening and reconsideration of decisions previously rendered. In most cases, if the BIA affirms the lower court's decision, then you can still appeal in a U.S. Court of Appeals. Immigration appeal forms. To appeal before the BI, the applicant must file a notice of appeal, EOIR 26, and required fee, so that is received within 30 days of the immigration judge's decision. The EOIR 26 must be used only to appeal a decision made by an immigration judge. Instead, if you wish to appeal certain USCIS decision, you must use the Form EOIR 29, Notice of Appeal, to the Board of Immigration Appeals, from a decision of an immigration officer. The EOIR 29 should be used to appeal a USCIS decision on a Form I-130, Petition for Alien Relative, or Form I-360, Petition for a Malaysian, Widow, or Special Immigrant. The filing fee of both forms is currently $110 and must be paid by check or money order. You must send the notice of appeal so that it is received by the BI within 30 calendar days after the immigration judge's oral decision, or within 30 calendar days after the date the immigration judge's written decision was mailed. The notice of appeal must arrive at the BIA in 30 days, or less. If it arrives late, your appeal will be summarily dismissed. A certificate of service must also be included with the EOIR 26, stating that service of the notice was made on the office of the Chief Counsel. All correspondence to the BIA must include a certificate of service to the office of the Chief Counsel. It should also be sent by certified mail return receipt requested, Federal Express, or other overnight delivery service. Your attorney may file an additional written brief or statement at a later date, and the BIA will send a briefing schedule and, when appropriate, a transcript of the testimony. Your attorney may also ask for oral argument, and the BIA will notify if the request is granted. Most appeals are reviewed by a single board member. If you claim that your appeal warrants review by a 3-board member panel, you may identify the specific factual or legal basis for your contention. Call our office right away if you have an outstanding deportation order and wish to appeal to the Board of Immigration Appeals.